readers. So I think that aspect needs to be put into perspective. And
Right.
what I'm trying to do in copyright is to put a check on the monopoly pricing of that corporate sector.
Right.
Now that we have a consensus, that have we started the conversation among?
We'll just go live now. We have actually gone live, so
Okay.
we're going to now start the conversation formally. So,
All right.
good morning to you from Delhi, and Professor Willinsky joins us on a Sunday night. Professor Willinsky, without getting into a very long introduction, is an emeritus professor at the Khosla Family Professor at Stanford, and one of the primary drivers of the copyright conversation that is happening in the world, and a co-founder and a founder of the Public Knowledge Project, which today has the open journal system, it has the open manuscript system, and also a system for preprints. With this and a short introduction, but an effective one, I welcome Professor Willinsky, and we're going to kickstart this conversation about his book, Copyright is Broken, which is available to get for free and open access through different mediums on the web. But the silver mark chair option directly on the web, the first one that you get, is the best one to get it. It's a slim book and packs quite a few arguments about why the copyright system needs to be reevaluated to come up to stand in the 21st century. With this, welcome.
Thank you, Amog. It's a pleasure to be here.
Thank you. The pleasure is all ours. So first question. So
Yes.
For those of us who are going to be having this conversation and who are going to be listening to this conversation later and who are not really up to date about the publishing and the academic world, but they're curious about using academic inputs to do research, they could be journalists, they could be public policy professionals. What is the problem with the copyright as it is right now in the United States, but also more broadly and generally in the world?
Yes, thank you for that question. It's a very good starting point. We need to understand that copyright is designed to protect authors, to protect the rights of authors in terms of their work and their investment in their work. And while it worked in the age of print very well, in which research was just considered to be another form, a literary form, in fact, in most copyright acts, it protected the publisher and protected the author. What's changed is the 21st century and the age of the internet, the digital era, has brought us to a point where we can now see that research needs to operate on a different principle. Research is not just another form of novels or plays or movies or video games. Research has a particular impetus, and that is the improvement of science, the progress and promoting the progress of science, as it says in the US Constitution, but also the benefit to humankind. That the more it circulates, the more widely it circulates, the more trustworthy it is, and the greater the benefits that can be shared and built upon by others. So I'm suggesting that it's time to reconsider research as a publication, scholarly publications and research publications, and to consider how they can be accelerated in terms of that sharing and the benefits that can be gained. So it's really a starting point that says copyright has done a very good job in the age of print for research and for other cultural forms. But now that we have this new era, this digital era, which has, by the way, seen changes for video games and phones and streaming, music and other areas, it has not seen a change for research. And research has been changed by the digital era. I'm sure we're all aware of that. So we need an updating of the Copyright Act in every country. We have international agreements that would help with that. And then we need to consider the new goals for research that distinguish it from other cultural forms. And in particular, it's the author's interest not to get rich. They don't get paid for these publications. Their interest is having their work shared and their work built upon. And copyright does not support that. Copyright supports the exclusivity of rights, not the sharing and building, which for research at least, not for all forms, but for research, is critical to its contribution. Was that too much?
No, absolutely fine. So now that we have kind of established some element of what is the problem with the copyright as it exists right now, the second question and the second step to this discovery would be, what you argue in the book that the copyright system is broken, and I tend to agree with you, but let me play the
Thank you.
devil's advocate and ask you, why do we need to, because the point that you're making, that legally we need to have a redefinition and a reevaluation of the copyright law completely when it comes to research. But why can't we use the subscription based model? Why is it that we can't make any incremental change in this traditional publishing? Why do we need to go out and invent a newer form of how we access research? Tell me a little bit about that.
I would start with the pandemic. I would start with the emergencies that humankind is facing. I would start with climate change. I would start with a sense of urgency that this science and research needs to be shared. It's just as much a matter of racial prejudice, of discrimination, of all of the social and scientific aspects that humankind currently faces. There is a need for radical change in terms of the sharing of this knowledge. We have had incremental changes. For 4 or 5 years, we've been trying to reduce the period of time in which publishers can restrict open access once it's been required. And we're very close to reducing that embargo period, that period where publishers are required to share it, from 24 months to 12 months to close to 0. But that's 4 or 5 years. We have for 20 years, or maybe 30 years, but I would say 20 years, argued for the value of open access, and we have barely reached the halfway point. So another 20 years? How many pandemics, Professor Ray, how many pandemics will there be? And how many climate crises will there be over the next 20 years? I can't wait. I have grandchildren. I have a family. I want to see the knowledge shared now. So incrementalism has value. We have seen incremental changes. What I've tried to do with this book is to say it doesn't need to be incremental. There is a way to resolve this, and that's simply to direct copyright to deal specifically with research publications, which it doesn't do now. There's no provision for research publications. There is for choreography. There are special provisions for pantomime, but not for research publications. Now, I'm a big fan of Marcel Marceau and pantomime, but I think there's an importance here that needs to be recognized for research publications. And we also have a point that I haven't raised yet, and that is we have a consensus. It has taken us 15, 18, 20 years to get a consensus among publishers, libraries, researchers, funders, and the public that open access is the best thing for research. The pandemic did a great deal to contribute to that. Now that we have a consensus, we can change the law. In the US, we talk about an iron law of consensus for copyright. Without a consensus, you cannot change the law. Well, we have that now. So 5 years ago, I was not advocating copyright change. We didn't have that consensus. Now we do. We're all agreed. And when all the stakeholders are agreed, we can work out, perhaps not my version, but we can work out an agreement on how copyright can begin to address, can leave the age of print, a wonderful age. I'm very fond of it. You've got the books behind you to prove your fondness of it. But we need to think about a digital era that will serve humankind better in terms of access to knowledge and the building we need to do on that knowledge.
Thank you. That was very impassioned. But I'm going to hold you to this for a while longer, because I want to understand this from the traditional publisher's point of view.
Please.
Because the argument that keeps on coming up, and this is an argument that we have heard in the developing world. I don't know if this is the same argument that is used in what are referred to as the weird Western, educated, industrialized, rich democratic countries. But in the non-weird part of the world, what we've heard is that with open access, there is mushrooming of journals, and these journals are we have in India a list called the predatory journal list, and a lot of journals keep on getting added to it um, because the university system in India has recently blossomed. So you have something like thousand plus universities, and every university wants to attract the same kind of talent pool to come and study with them, to kind of come and work for them. So how do you recognize a good university from bad one? A, number of publications. Are you on list X? Are you on rank Y? So on and so forth. The traditional metrics, which are the same in your part of the world as well. But then, how do you promote a professor? How do you, so if I'm an associate professor, how do I become a professor? If I'm doing my PhD, if I'm breaking into the academic world, am I a good candidate for job or not? One component of it is teaching and learning. How good am I with the students? But of course, a larger chunk of it is predicated on my ability to publish papers and get these very scarce things called grants, academic grants from different bodies. The moment you get into this, the traditional publishers argue that they have a vetting process which is much more developed and which is much more intricately linked to the knowledge production machine. When I read your book, I have a sense that is not the ultimate form of arbitration of scholarship, that we can have better metrics. So I want you to kind of develop that thesis for the people who are going to be listening it later.
Okay. All right. You're doing a good job on behalf of the devil, by the way, as an advocate. So I appreciate that. I want to say that I have decided, I've been involved in open access for 25 years, and I've decided a couple of things. One is to respect my colleagues who are very much involved in searching for ranking, citation, impact factors, and other elements of measures. I'm not touching that. I'm saying that ranking system and rating system and measurements are an important part of what my colleagues believe is necessary for science. I only want the research to be freely circulated. So I want Elsevier, I want the most expensive journals to be free and open to readers and to authors. And I want the publishers, to be paid, but with a price check. So the most radical aspect that I'm introducing in terms of a proposal for copyright reform is that there is a court, there is a copyright board that reviews the pricing. Now, if that seems absolutely ludicrous, can I bring in my friend Taylor Swift? Because Taylor Swift, as a musician, has been a champion of copyright reform and has made and seen through changes in the music industry that has price checks. And I was stunned to learn this didn't start with Taylor Swift, but started 100 years ago when there was felt to be a monopoly among music publishers. And the US government introduced price checks. That is, the price has to be argued, decided by a judicial body. And so what happened is that they introduced it in 1909, and it has survived for over 100 years. And the major publishers have gotten rich and all of that sort of thing. But we do have no monopoly pricing in music. We do have some fair basis for Taylor Swift to do very, very well on her tours, but to get the same price as the starving musician when someone listens to her work on streaming. So I'm only asking that we borrow some of the strategies that have been proven over time to address two issues. One is the one about how much it costs to publish. And I'm not ruling the publishers out. Let me just stay for a second on that. They can go before the copyright judges in the United States that are deciding music pricing right now. The scholarly publishers can go and argue that this is what they need. But the judges have to listen to the librarians, have to listen to the small institutions, and have to decide on what is a fair price. And we don't have that right now. So open access has been kidnapped in a way, as being held hostage for very high article processing charges. And that is a spoiler, and that is a source of inequity. And it's been addressed in the music industry. And I'm arguing, following the example of Taylor Swift, that it can be addressed. Taylor Swift actually introduced it for streaming. She pulled her music off Spotify because streaming was not part of the Copyright Act. And 4 years later, they changed the Copyright Act in the United States so that streaming was included, but they did not let Taylor Swift set the price. They said it had to be decided by copyright judges on a fair basis for all concerned. And that, to me, is a very important aspect. The other is universal open access. The publisher does not get to decide what's going to be open and what's not. It has to be universal, and it has to be at a fair price. Those are the two principles. Everything else that you addressed about how do we establish to become a full professor, when do I get into nature, when do I get into science, all of those things I'm not changing. Other people can change those. I didn't want to spoil it for everyone. I want to give others a chance for reform. I'm just addressing two issues: the pricing and the universality of open access. Let the others fight about status, prestige, impact factors, and the rest.
Thank you. Now that you brought Taylor Swift, that would be my next question. But I'm now back on the open access side. So the Public Knowledge Project, you founded it, if I remember from an interview that you gave correctly, because you were writing an article for a Canadian newspaper, and you wanted to link your own research, if I'm not wrong, or somebody else's research,
Yes.
but you could not link it due to copyright issues, and that was the funding and the starting of the Public Knowledge Project. It started with a journal system, and now it's pretty impressive. In fact, we publish quite a few monographs and books, and we are in the process of migrating to open the manuscript, the monograph version, the OMS.
Yes.
So I really like the project. Kudos on that.
Thank you.
It's constantly growing. And so tell me a little bit about how does the economics of the journal work? Because pricing is an important part, and you just talked about it. Why does it take, let's say, $2,000 for a journal that shall go nameless to have an APC of $2,000 to publish an open access? Whereas I've seen quite a few journals that use PKP, and they are relatively free. They charge a small amount of money, say $39 or $40 in some cases, very rarely, but they don't charge $2,000. So tell me, where does this $2,000 come in? And where does the copyright come into play in this? Because the argument is copyright.
Yes. And I want to stay focused on that. I appreciate your very kind comments about the Public Knowledge Project. I started in 1998. So I'm speaking from 25, 26, 27 years of experience in this. The whole purpose of the Public Knowledge Project was to make knowledge public. We've developed open journal systems, the platform, the open source free publishing platform, thinking that if we developed a free publishing platform, everyone would publish on it and we wouldn't need commercial publishers anymore. I was wrong. My colleagues, the entire professorate of the world, have decided they want and will retain. So we have had great success with OJS, Open Journal Systems. We have over 45,000 journals using it, but they are not the most prestigious ones. They're not those that Elsevier and Springer Nature and others are publishing. And so I've come to understand that we need to do more than just develop a platform. The goal was never to be the one publisher or the one publishing platform for the world. The goal was to convince people another world was possible, another way of approaching it. So really, in some ways, this copyright reform that I'm talking about is not about the Public Knowledge Project. We don't need it. We don't need price checks because we think that 85% of our journals are not charging authors anything and not charging readers. We have developed an economic model called subscribe to open that commercial journals are using. Let me just describe it for a moment because it's like the effect that I'm trying to achieve with copyright reform. Subscribe to open says, or starts with the assumption that libraries want open access. Libraries are in the business of sharing knowledge. So why not say to a library, why don't you subscribe to open access for this journal instead of subscribing to closed access for this journal? And what we have found, what 26 publishers have found, is it works. The libraries are willing to subscribe to the journals being open. And they're willing to pay the same price they paid before for the subscription. So this doesn't address why one journal costs $3,000 and one journal costs $600 to subscribe to. It doesn't address that. And Professor Ray, you have to appreciate that the only effective argument is going to be a limited argument, not an argument that addresses every single aspect. So we're setting aside why there are differences and saying that libraries are willing to pay what they paid before, even those big price differences, and have the journal open. And this is a growing model called subscribe to open. And it's the same effect I'm trying to get by law because it's taking too long. 26 publishers? There are thousands of publishers. I can't wait. What we want with the law is the libraries would pay the publishers a fair price. Now, subscribe to open doesn't have a fair price. It doesn't have a check. Sorry, I shouldn't say it doesn't have a fair price. That's unfair. It doesn't have a price check third-party judicial body to decide the price. That's set by the publisher. What I'm suggesting is that the libraries and funders would be required by law to pay a fair price that they participated in. The libraries and funders are able to go before the copyright judges or the copyright board and argue for a fair price, just as the publishers are. And those two bodies can come together because they are experts, specialists. We take the researchers out of the equation. Right now, researchers are making bad decisions. They'll pay $10,000 to get in, $12,000 to get into Nature. That's a good investment in your career, but it's not a good value for sharing knowledge. And so we're saying, let's move the researchers out of this. They're tired of it. They don't have the time to focus on it. And let's bring the professionals, the librarians, the funders, the publishers together and set a fair price. And although it will differ for Nature and for a small journal coming out of a university department of history, we at least have a chance to speak, to decide what is fair compensation. And that will reduce some of the extremes, some of the highest pricing. So the reason I'm arguing for a change in copyright reform is we have the ideas, but we don't have the force of law, and we cannot wait when humankind faces the challenges it's currently facing.
I absolutely agree with you on this. And I think this is an interesting way that it could be done. But I now would like to go back to your friend Taylor Swift and her decision to pull off tracks from streaming services. And then kind of once the streaming was brought within the purview of the Copyright Act, in the book you talk about licensing. Essentially, in the music world, the statutory licensing that is applicable. And you make a very interesting connection between two very different worlds. And you have an idea for connecting one with the other. Tell us a bit about this licensing model. And if I might ask you a follow-up question on the licensing thing, most of the research in the world is funded by governments. I mean, at least in our part of the world, most of the research is being funded by the government. And then that research has to be published in very expensive journals. And I don't understand why should the funder, the main funder, the government, not have a say in making that research open access? And
Yes.
how does the licensing model follow through on this? So, two questions. Sorry if
Okay.
they are
No,
conjoined.
no, that's fine. So let's introduce this formal clause, this formal term of statutory licensing, also called compulsory licensing. This is what was introduced in music in 1909 in the United States. It's compulsory in the sense that the price is not set by the market. The government intervenes. It's compulsory in the sense that this license fee will apply to all within the category of music, and it includes things like performance rights, publication, lyrics, all of these different aspects of music. And in the case that I'm proposing, and I'm really using it because it's a legal remedy, it addresses a question of monopoly. And it says that the market has failed to deliver a fair price. Now, I don't know if you would agree with me that the market has failed to deliver a fair price for research publications, and that you think that $12,000 for Nature articles is a fair price compared to, okay. So we have an agreement there then, Professor Ray. So that is called a market failure. The market is not doing it, its invisible hand is not working as it should be. The hand is not just invisible, it's not even present. And so it intervenes, the government intervenes with a statutory license that requires all participants to be a part of the transaction. And in this case, I'm making libraries. And so in the music industry, you could say, well, Taylor Swift's music is not free. And I would say, yes, of course. And I don't want research publications to be free either. I want the principal users, the agents of researchers, which are the libraries, and the funders of research to have a say. I want the funders to be able to go to the courts and say, we're spending too much on publishing, not enough on research. That $12,000 APC, that could have funded an extension of the research with $2,000 left over for publication. And so that ability to appear before a court because the market has not worked, if at some future time the publisher said, okay, we get it, we don't need to negotiate our prices before a judge, we will give you a fair price, then the statutory license could be revoked. That's always a possibility. In fact, it has been revoked in a couple of cases in music around jukeboxes, but it's a little too late for jukeboxes. So it is I'm trying to come up with precedents. I'm trying to come up with legal remedies that have been proven. I don't want people to accept that I have this brilliant idea myself and you should take hold of it, this harebrained notion. No, I want to take proven law, not just Taylor Swift, but law that is well established and has solved similar problems. It will be different. Readers will not pay as they pay for Taylor, their libraries, the university libraries, for everybody in the community. And the funders have a goal in sharing the knowledge they invest in. The funders are served by publication. They should pay. And it should be a fair price. It may be different for different kinds of publications, and that can be justified. Nature can explain that they have statisticians on their payroll that other journals don't have to check the stats. And that's a valuable service, and we would have to accept that. I would, at least. Publishers can say, we have a new indexing system that's vastly superior. And libraries can say, we like it, but we'll pay for it only this far. Only this much of that system do we want. So to have that kind of discussion about what we value in scientific publications is what I want to have that opportunity to have right now. Instead of a monopoly where Elsevier says, here's the offer, take it or we're walking. Which they've done in California, in Germany.
Yeah, and they've been successful at it.
I'm afraid so.
But then, when we are talking about access to research, I think Peter Baldwin, who you credit also in the book as one of the people that you have, and I think Athena Unbound, and these two books are my go-to books for kind of coming up to arguments about the, because I intrinsically, I mean, I'm not an advocate of the traditional subscription model, but it was my job to ask you those questions because these are the way they are framed whenever we try and introduce the element of cost and accessibility, two issues that you focus on quite a bit. But let's take a step back. One of the biggest funders of this exercise in our part of the world is the government, and also largely in, even in the United States, the government of the United States spends a lot of money to do research and fund research in various mechanisms. The National Institutes of Health, for example, to cite just one very important body. But there are also these things called standards and codes. And currently, a very dear friend of mine, Karl Malamed, is being sued left, right, and center for putting out their standards, legal standards and other codes onto the web for free. In fact, he has done tremendous work in India as well, where he put out the codes of the standard codes online. And then, after a bit of litigation, the government of India decided that perhaps the standards ought to be free after all. So, the incentive for the government and the access to knowledge not being free as an argument, because paywalling it makes it easier for them to control how much information goes out. Why don't we also relook at some of our assumptions about standards, codes, and other issues that are currently paywalled and gatekept by large organizations? Somebody I really looked up to was Aaron Schwartz, and Jay Stern, and that entire case was a travesty of justice. I would like to understand from you, because you have this proposal of reorienting the copyright law, and because technology is going to constantly change, how do we put in motion a clause that opens the access to immediate and important knowledge to everybody, despite ownership and control of different bodies?
Let me say that you introduced a couple of issues there, Professor Ray. One was this notion of what about codes and standards? I've really been inspired by India's work in generic drugs. So India has led the world in terms of patents, and enabling generic drugs, and in fact is the generic drug manufacturer for the world, and has played a key role in COVID and in other areas. And so there are other developments that have parallels that are related to opening up knowledge. And I take generic drugs to be a way of opening up the application of knowledge. So I have focused, let me say, not so much specialized, but I have focused very closely on one aspect with two dimensions. That is the universality and the sustainability of open access to research publications. Nothing about patents in mind, nothing about standards or for example, government documents that are not shared publicly. So I think we need to use our expertise to come in on a very specific aspect and build a carefully worked element. It's like putting together a clock. You cannot have anything in that clock except what produces accurate time. And you cannot address all the other questions that might be raised about the meaning of time, or the time in terms of work, play, or family life balance. Those things can't be addressed if you're building a clock. So I perhaps lose people on this because people have a lot of other issues they want to see me address, or they want to see anyone address. And I have found in presenting my case for copyright reform is you need to have that focus, and that costs you people's support because they would like, the expert person to have an opinion on everything. So I'm happy to weigh in on other things, but I think in terms of the effectiveness of an argument, in terms of creating change and focus, one of us or some of us have to be so narrowly tuned in that, and I don't just listen to Taylor Swift music, by the way. I'm not that tuned in. It's not one among my favorites even, but I look for those examples. We have to be inspired to find examples. We have to work from proven instances. We have to work from analogous and adjacent areas. And that's what I've tried to do with this book. It's narrowly focused on two aspects of access and universality of access and the pricing and fairness of access. It is different than the Public Knowledge Project's other work in terms of developing platforms. So I would say that part of the response that I found in terms of this project is people have a preference for the incremental. It is a major change. There's a fear that if we open up the law, the publishers will pile in and be terribly unfair with everyone and take advantage of their great lobbying power. But I have trust that we have an agreement about open access. I have trust in this consensus. I have trust on my colleagues that are publishing, as well as my colleagues that are researchers. And I think we can arrive at an agreement that, again, may not be exactly as I specify. It may even disappoint Taylor Swift, for heaven's sakes, but can be a better way of gaining universality and fairness when it comes to the circulation of knowledge.
Right. And the reason I put in the question about standards and other things is because copyright is used to safeguard it.
Yes.
And perhaps a comment on it. But let's get back to academic publishing. And we'll come to the proposals that you have, because the proposals are interesting and thought-provoking, and I would like you to kind of explain to people. But before I do, I have another additional question, which kind of might sidetrack from the conversation that we should be having, but it's an important question to ask. In the context of the rest of the world, there is this body called the USTR, and they produce a report called the USTR 401, the United States Trade Representatives. They advise the President of the United States about trade. And copyright infringements make for a very interesting reading in the USTR. So, for example, I'm in India, and India, because of what you just said, the generic drugs. So there is a special provision in the Patent Act which made that particular thing possible. And a lot of pharmaceutical companies have always wanted to do away with that. Consequently, along with China, Russia, we always find ourselves pretty high on the USTR list. Copyright infringements also, largely in tech, but also in some academic publications, make us proud placeholders on that list. How do we generate enough consensus within the universities of the world that larger universities with 37, 38, $39 billion in endowments don't necessarily have to side with large publishers? They might side with other knowledge creation bodies like nonprofits, universities, and advocate for a better, freer model of accessing and producing knowledge. So my question is, if there are universities in the East, be it China, be it India, be it any other country, what is that standardized model? I mean, we are prescribed a standard model that this is the best model of publication and this is what you have to follow. If you don't follow that, then you'll have penalties. So what should be the antidote to this big publishing hold on the academic output and inclusion on lists such as the USTR 401? So how do we get out of it?
Let me address this in a couple of ways. One is to say that 28 years ago, I set out to create an alternate model, a different way of publishing, that would be return publishing to the academy, would not go out to commercial sources, and to offer a platform that would do that, a free platform that was built within the academy. And I still build that. Every day, I worked on it today. And so we are still continuing with that approach. And we are saying that there is a way for the academy to take back publishing. And our platform is used in India. Our platform is used around the world. 80% of the journals that use our platform are in the global south. But I've come to a point at the same time where my responsibilities are larger than that. I've come to accept that even though we have, as I say, over 45,000 journals using this free platform, with 85% of those diamond, that is no charge for authors or no charge for readers, that's not the whole of research. And this is my contribution to say that it's not me against you, it is we should work together. I've got something in this for publishers, a guaranteed price, not the price they set, but still guaranteed. They must be compensated by libraries and funders when they publish research publications. Now, as you say, we'll get into some of the technical parts where there's some controversy about what is a research publication. But that very point you made about predatory journals is part of this issue. If we bring research publications into the Copyright Act, then we can start talking about what is legally a research publication. And predatory journals without peer review are not. And we're very proud of the fact that less than 1.5% of the journals using OJS are on questionable lists at best, produced by Beale and by Cabell's. So we do, in a way, need to acknowledge that the world needs alternates, variations, but we can't wait for the world to arrive at this ideal state. We need to be working on multiple fronts. And so we develop a free publishing platform to offer the world on the one hand, and we say the law could be changed, albeit in a thorough way, to introduce statutory publishing that will speak to all publishers, whatever platform they use, all libraries, all funders, whatever country they're situated in. And the inequalities of these well-endowed universities, and Stanford University is right up there, I recognize that, is to say that they are already supporting at very different levels, that there are tiered subscription charges, for example, and tiered pricing for APCs that is now being proposed by Coalition S. And those elements of fairness will be in place. If a library did not subscribe to journals, it won't be paying into this new system. That won't change. And so it takes the current economy, about $10 billion a year, and says, one, that's sufficient. In fact, I think it's too much. We want to negotiate a fair price, more like 6 billion. Sorry, did I say billion? No, it's billion, 10 billion. And so in that way, we're suggesting that we can put an additional pressure, if you like, or approach. We have an alternative diamond open access model, no charges for readers or for authors, and we have a commercial model that needs price checks. And it's not either or, because both of these exist. And we are not going to wait until the one we don't like goes away.
Well, that gets me to the conversation that gets us back to the book. So in your book, you propose new copyright categories. You just alluded to that. And you also talk about tailored legal frameworks. So I would like to understand that in a bit more depth with some examples, because uh, I understand the intricacies of it. So, what you're proposing, that research articles be accepted within the copyright definition as you talked about. But then you also make very interesting thing about the classification mechanisms that are already being used. So I would now like to understand that, hopefully with an example, if possible.
Okay. So your listeners need to understand that I'm introducing research publications, that term, into the Copyright Act. It's not there currently. As I mentioned, choreography is architectural drawings, pantomime. So research publications would take some definition. What is a research publication? And we have a definition. In fact, we have a whole profession of librarian, information science, that deals in what is a research publication. And they're making decisions, librarians, every day about what is a good research publication. They consult with faculty on it. So we would have to set up a mechanism for deciding what is a research publication. And that has been a source of controversy. I have been accused of being the Stalin of copyright reform because I want the government to be involved. I want the legal system to be involved. What this would mean is we would have a board of librarians and publishers who would review difficult cases. Is gray literature a research publication? Well, no, if it's not peer reviewed, that's easy. But what if it has peer review? Okay, then it's a candidate. So this aspect of deciding what is a research publication would be something that would have to have an active committee in every jurisdiction, and special edge cases would have to be reviewed. But it's the same work that librarians do every day for their institutions, for their colleagues among the faculty, for students whom they advise on what they should be reading and consulting. That's not a research publication. You shouldn't use that in your paper. So I think we have, that music industry doesn't have, we have information scientists. We have great indexing, multiple indexes that list research. The music industry doesn't have that. We know who the author is. In the music industry, it's often a dispute. So we are, as it turns out, well equipped, very professionally strong, with great expertise in deciding this. That would be a key aspect. Now, none of this is to be, I don't want to oversimplify it. I understand it's controversial, but I am amazed by the confluence of forces, like our ability to talk about who owns, whether it's a research publication, has it been peer reviewed? And we want to do more of that. That's why predatory journals would not survive under this copyright law, because they would not qualify for any funding. And authors would not be making foolish decisions about publishing in predatory journals, because the Copyright Board would say that is not. There is no evidence of peer review.
So, when a journal is new in this system,
Yes.
You have, let's say, we start a journal and we call it the Asia Review, and we don't want to. It takes a few years for a journal to be established. So, within the new system, what are the challenges that are going to be faced by journals that are just up and coming, and that they do not have the history, and perhaps a newer journal might have an editorial board which is largely young or middle professionals in that particular academic body.
Like you and me.
Well, I like me, but not like you. You are far too
Geriatric.
accomplished for that. So, so in this, what I'm trying to understand is that in the scientific publication, why And because you're talking about redesigning the Copyright Act and opening it up, why can't it just be done compulsorily? Because later on in the book, you argue about financing. So, and APC is just the cost of publication. It's not the cost at which a journal is sold to you. So why can't we just have it for every journal, that one standard price? Why would you want to differentiate between a new journal and an old journal?
So, Professor Ray, you would have a chance to go before the Copyright Board and argue that. You would have an opportunity to bring evidence to bear on a single price. But you would have to face the publishers who say, we have 5 statisticians in this journal, and we have no statisticians in this journal. And that's why there's a difference in price. But this idea that, what about new journals? Now, I hope you'll forgive me if I take one more music example. But because, and this is, all right, no Taylor Swift in this one. The music industry, what I was amazed to see is that they tax all the publishers to create a fund for new publishers, new musicians, new bands, because they realize it's very hard to break into the industry. And we would do a similar kind of process. It's in the law that they need to contribute to support new talent. And in fact, they need to establish and prove that they are not operating as a monopoly. They are not excluding new bands or musicians, because that would be to act as a monopoly. And so these protections took years to develop. These protections arose out of bad situations. And we can benefit from that 120 odd years, 115 years, that in the case of the United States, and again, the things that happen in the United States are not determinant of the world. We have WIPO. We have a United Nations body, the World Intellectual Property Organization, that makes decisions, that gives the world a chance to speak to each other about intellectual property issues, including copyright. And so this idea that the world would come together through WIPO and other organizations to discuss what would be fair for each country is an aspect of this. The fact that the music industry supports new, as it were, journals or musicians doesn't have to be adopted, but it is part of what I have done. Part of the legwork for me was to discover, how could this happen? New journals are critical. Women's studies in the 1970s was born on the basis of new journals that gave women a chance to speak out. And so the vitality of our intellectual lives as academics is based on new journals. There has to be a mechanism that will enable that. And it turns out the music industry, now, the music industry will, if you speak to anyone, they will say the starving musicians on the fringes are still starving. It hasn't fixed everything. The busker that you see at the bus station is still busking. It doesn't guarantee an income. So I'm not suggesting every little thing is going to be fixed, but a big issue like new journals, young academics, new fields, that has been addressed.
Right. So there are quite a few reform advocacy and other things that are happening. Would you want to tell us a little bit about that?
Yes, I'm not the only, surprise, I'm not the only one proposing copyright reform. There are 2 other major initiatives that I really need to acknowledge as inspirations for what I've done. Perhaps the most widespread one is secondary publishing rights. There are 5 countries in Europe that have introduced secondary publishing rights. And what this means is the author retains a secondary publishing right. Even if you publish with a commercial publisher like Elsevier, in countries like Italy and Switzerland, I hope I have that right, the author can, after a certain period of time, make their work open access. They have a publishing right to make their work open. Now, it only applies to government-sponsored research. That means it's a minority. It's not half the research that is government-sponsored. It allows the publisher to have an embargo period of 1 to 2 years, or sorry, probably more often 6 months to a year. So the work is not immediately, when it's fresh, when it can make its biggest contribution, it's not open. And it allows the final copy, the final draft, rather than the published version. So it's not even the real thing. So secondary publishing rights, which were very important 10 years ago in terms of this introduction of open access, were very important secondary publishing rights in terms of establishing the interest that authors have in it. But they also rely on authors who are not paying attention to this. And so secondary publishing rights is an important element. It's established that governments are willing to make changes for research in at least 5 countries in the world. But it is incremental because the secondary publishing rights are going to the zero embargo. You don't have to wait 6 to 12 months before you make it free. But that's taken 5 years, 4 or 5 years in terms of the United States and its considerations of that. The second, and I realize we're running out of time here, the second move in terms of the right to research is the notion of exceptions. Copyright exceptions. So in Canada, it's fair dealing, where I'm from, but I'm living in the United States now, it's where it's fair use. Those are exceptions. So we could make an exception. We could strengthen the exceptions, the fair use and fair dealing exceptions, I'm sure in Indian copyright too, to include research. But I object to that because research is not an exception to copyright. Copyright is born out of a need to protect and promote the progress of science. It's not an exception. And the exceptions are on the basis of use. If you use something for research, then you have a special right, an exception from copyright. You can use it without permission. But it's not about the use, it's access to the work itself. You're not going to use the whole of a journal, but you have a right to that journal, that knowledge. So the exception, now where exceptions get interesting, just for a second here, is on AI, the large language models, because the exception is fair use to scrape the web, information and research on the web. Big fights are going on, multiple cases are before the courts right now in the United States and elsewhere. In the New York Times is one suing on this basis. Sarah Silverman, John Grisham are suing on this basis that their work was unfairly scraped. And we're waiting for the courts to decide on this. Certainly there's an argument for researchers to build large language models for research purposes by scraping under fair use. It does fall under fair use because it's transformative, and I won't get into the technical aspects. So my measure, statutory licensing, is one of 3 principal ways promoting access to research. One, the secondary publishing rights, which is limited and very incremental. The second is the exceptions, strengthening the exceptions, which I categorically am uncomfortable with because research is not an exception, but it has possibilities. It certainly worked well in photocopying, making it a matter of fair use. But my proposal for statutory licensing may be too radical because it solves the problem of pricing, which the other 2 don't even address. Secondary publishing rights don't address pricing. Exceptions don't address pricing, although making an exception maybe gets away from pricing. The second is universality. The exception will have limits, and the secondary publishing rights currently apply to government work. That's only a portion. I'm suggesting universal, including back issues, old research. I work in the humanities. I need older research as much as I need today's, the long tail of research we talk about in the humanities. Socrates and Plato, Socrates. Plato's work on Socrates needs to be freely available.
That is a radical idea, and we are just about to hit the 1 hour mark. So last 2 questions, and then my second last question is, throughout the book, and there are a lot of incidences that I have not gone into, but you propose a solid plan on trying to open up the copyright grapple hold and kind of make research accessible to everybody. My question is on the aftermath. something, because you are proposing a new traditional and non-traditional publishing system. My question is, how do we measure it? In a way, I'd asked you this question earlier as well. What would be the metric that we have to use to say that, okay, this model is working now? Of course, price and universality will have to be built into it, but beyond that, what else?
Readership is the biggest measure. We will see a huge increase in readership in high schools, among the professions. Your family doctor will have access to research they didn't have previously. So readership is the number one. The second would be scientific gains, increases in citation of work, and the speed with which, again, the pandemic was the best proof. The publishers made their work open access around COVID. All of them made their work freely available. What happened? We had a vaccine in 6 months like we had never had before. India participated in that process of taking advantage. So the proof and the measure, in a sense, has been field tested. We've had a natural, I don't want to say natural, an unnatural, a tragic experiment with open access. When the publishers opened their work, they knew immediately that keeping their work closed impeded the fate, the future of humankind. That is a measure. The lives that were saved, the reduction in mortality rate over that period of time, and the arrival of vaccines in record time. Now, there are other reasons for that. I don't want to get into the complexities of the RNA work that had been done prior that led up to the vaccines, but it was a contributing factor. And if that's not clear, then I'm afraid we're going to get other examples where we can establish that, because that is not the last pandemic we're going to face.
Well, that's a fair warning, and I agree with you. And not just pandemic. I think climate change. I live in a country where the median is getting very interesting because the rains and the incidences of heat wave, etc. They're building up, and we have to figure out a way. But moving on to the last question, you talked about it a bit. Generative AI. It's a matter of time that generative AI comes to scientific research. And what we are seeing in terms of chat GPT and even other models, why should I just focus on one, but Claude and any other model out there, can go through a lot of information in a particular domain. It can be the popular domain. And we start getting a lot of stuff regurgitated. And that's wonderful. But that is not human creativity, and that is not creativity. It's a form of regurgitation. When it comes to scientific publications, how do we ensure that the generative AI model kind of fits within the purview of the copyright change that you are advocating for? Because big tech is a much more, for I'll have to have an apology, but insidious production system than big publishing. So how do we safeguard? How do we safeguard scientific research from that?
Yes. I would say that that is something that is in progress. As I said, the cases are before the courts. We have not had legal rulings yet on what is fair use in terms of the AI's ability to scrape the web, the AI, the open large language models, excuse me. And the question about production, about copyright protection, many of the publishers have taken stands very quickly to say that they will not allow authorship. They will not grant authorship to ChatGPT, for the very instance you used. And so therefore, if they do not grant authorship, then there's no copyright protection for the creation of AI systems. So we have these things still to be decided. It does not, in a sense, determine. I have my own personal interests in terms of seeing more research involved in large language models, because then we would have more reliable production. Generative AI is generative with very little research because it's been closed. I have concerns about the publishers selling research to OpenAI and to putting their work, our work as researchers on the market for sale. But that's not a copyright issue. Well, it is a copyright issue, but it is one in which we have turned our copyright over to the publishers. And so we have a number of issues still to work out, for sure. Generative AI is still very new. We haven't the laws, the legal structures, the court decisions. We haven't fully understood the implications of this. And you mentioned earlier about what does it mean when there's technological change? How will this proposal of mine be able to handle every change that comes in the future? And I would say that the courts will make rulings and that the law can be changed. That in fact, one of the principles of the law is its flexibility, is its ability to be altered. We have legislative assemblies, congresses, governments that can change the law. And by my reckoning, copyright has been changed 60 times in the United States since the internet was introduced. Not once for research, but multiple times for video and music. And so we can continue to adjust. So I don't want to make a prediction about AI that will be on tape, on YouTube, and will be cited back to me as being so wrong. What I want to say is that we have the means of dealing with these forces. I am not a doomsayer for AI. It will not turn us all into paperclip makers. We have a better future than that ahead of us. Thank you.
Thank you. Thank you so much for doing this conversation. Perhaps as a point of research, we could have a fair publishers index, something that gives us an idea about the challenge ahead, because there is need to kind of open up this conversation. And I think this book is a step in that direction. And thank you so much, not just for the conversation and your time today, but also for the work through Public Knowledge Project and this scholarly output.
Okay. Thank you, Professor Ray. It's been a pleasure.
Thank you.
An honor.
Thank you.